Welcome back to another episode of The Lawyer You Know, and today we're going to take another part of the Curtis Reeves trial. This time, some work done by the defense attorneys, and we're going to break it down and talk about it. And this is the cross-examination of one of the patrons that was there watching the movie the night of the shooting. And again, if you're just joining us, Curtis Reeves, former law enforcement officer who shot someone at a movie theater, allegedly over a bag of popcorn and a cell phone light being on during the previews, and now he is on trial for murder 8 years later, and he's claiming self-defense. Well, this witness that we're going to break down the cross-examination of was another person there watching the movie, but also an off-duty law enforcement officer, and that's going to come into play and be very important as we listen to this cross-examination, because off-duty law enforcement officers, or current or retired, or anybody with law enforcement officer training is going to know more than just your average layperson that's at the movie. They're going to know how you react in certain situations. They're going to know how an investigation is supposed to go. They're going to know how witness statements are supposed to be taken. They're going to know how to deal with a crime scene. And we're going to hear this defense attorney, Mr. Escobar, very good defense attorney, he digs into some of those points. And as with any good cross, he hits all the beats. He gets some information he needs and gets some hits on this witness. He needs to prove self-defense, so he's going to prove the actions and motions and size and stature of the victim, how they could be used then later in closing argument to show that this was necessary force to respond with deadly force. He's also going to impeach him with prior statements made just minutes earlier on direct examination. He's also going to impeach him with statements made the night of the shooting. And he's going to ask him, is your memory better then or is it better today? And this guy's going to say, well, it was better then, obviously, because that was right after this happened. So we're going to listen to this cross-examination. I'm going to jump in with my reactions and responses and thoughts on why he's doing certain things and why it's so effective, and things he does in the courtroom that we'll talk about too that are really effective. But I wanted to give a breakdown of some stuff the defense attorneys were doing. A lot of you asked about it, and I think this witness testified yesterday, and it was really interesting and a really good cross to give you an idea of what cross is supposed to look like in a case like this. Now, no smoking gun, no aha, no look, somebody else did it. You can point at them like in Legally Blonde where Elle Woods got her to say, yes, I did it. Nothing like that. This is a real life, effective, and well done cross. So let's jump into it.
When they played the previews there at that theater on January the 13th of 2014, the previews were loud.
Loud as,
Well, you remember RoboCop, right? That was one of the previews, right? It was action-packed, it was shooting, it was loud.
I just remember commercials, and they're loud. Enough where you can hear them. Yes,
I'm not talking about the commercials. I'm talking about the previews. These are the movies that they intend to show in the future. It was RoboCop, it was all those Terminator-type previews that day, correct?
Yes, sir.
And they were loud.
They were loud.
And they were shoot-'em-up type of previews, were they not?
Yes, sir.
So just to point out, the way he's asking questions, closed questions, directed questions, leading questions that he may not know the answer to. A lot of these he does know the answer to, but if the witness disagrees with them, he sounds stupid. He sounds like he's lying. Now, this was actually a really nice guy as a witness, so I don't want to say he is stupid or he's lying. But if you disagree that a shoot-'em-up movie is a loud preview or that it's loud in the movie theater during these previews, the jury knows. The jury's been there. So if you're like, yeah, the preview to RoboCop was really quiet, it wasn't loud at all, the jury's not going to believe you. So you can ask questions like that to where the witness has to agree with you whether or not you know the answer, as everybody says on cross. Don't ask a question you don't know the answer to. He's doing a really good job of that so far.
Both you and your wife are seated. You're paying attention to the previews, right?
Yes, sir.
You're looking to see what's coming up next that you may want to go see.
Yes, sir.
Look at Scott Rosenwasser in the back left corner. He does not look very happy. It looks like he almost knows what's coming with this cross. Sorry, I just noticed that.
And it was your wife that had to nudge you to get your attention, to focus your attention on something else.
Yes, sir.
And when you did that, when she did that, you scooted up. Correct?
Yes, sir.
And the first thing that you see is a person standing up, correct?
Yes, sir.
And what you see is really a silhouette, right?
That's correct.
You don't see my definitions that you see here, right?
No, sir.
You don't see clear skin color, color of my eyes, right?
No, sir.
You don't see the color of my frames, do you?
No, sir.
All you're seeing at that distance is a silhouette.
Yes, sir.
You know what a silhouette is?
Yes, sir.
So you're not able to see features.
No, sir.
And you can only see from the waist up?
Yes, sir.
And if you're wondering how he knows these things, again, we skipped direct examination, so a lot of it was testified on direct. He also made statements afterwards, and he's made other statements throughout this case, probably at a deposition. So these questions have already been asked and answered. That's why lawyers can be so confident on cross that they know what a witness said or what they saw or what they did when the event took place, because we know based on prior statements.
But you could tell that that silhouette was yelling in that theater.
At one point, yes, sir.
Yelling, right?
Right.
In fact, you're not only making that statement here yelling. You put that in your own written statement, did you not?
Yes, sir. That's correct.
And this tall man, right? He was tall.
Yes, sir.
You said at least over 6 feet.
Yes, sir.
Important, again, stature is important. A tall man, over 6 feet. Again, that presence can create this kind of fear that's reasonable that they're trying to set up for this self-defense case. So that's important. And again, got it confirmed from this witness. That's important.
This tall man was yelling, and he was leaning over the back of his seat.
No, sir. He was propped.
This is really important. So he was leaning over the back of his seat. So the whole time, in opening statement, we talked about how the prosecutor said an entire row and an entire seat to the right, acting like he's so far away. Well, I think that is going to come back to bite him, because they're going to talk about how all he had to do was lean over a seat to get in and invade the defendant, Curtis Reeves' personal space, and screaming at him and grabbing things and throwing things at him. I think they can build that narrative a little bit more than it may have sounded like in the prosecutor's opening and in some of the other witness statements that have already taken stand in this case. But what's really interesting is, on direct, you didn't see it because, or unless you watched it on your own, we didn't play it here because we didn't have 5 hours, but on direct, he said he was propped up, meaning just kind of stood here and even demonstrated it with the prosecutor. But in his statement after the actual shooting, the night of the shooting, it sounds like in his statement he said leaned over. And the defense attorney is going to make a big deal about that difference. And I think he's right to make a big deal about that difference. And we'll see why as he continues to ask him questions. But this is a very important distinction and time that he's going to impeach this witness based on a prior inconsistent statement.
You remember making a statement?
Yes, sir.
And you made that statement on the very day of this incident, correct?
That's correct. Yes, sir.
You made that statement even before you were interviewed by the detectives.
That's correct.
And you remember making this statement. I observed a white male standing up to my right and lean over his back seat and begin to yell something to the effect, I am trying to text my fucking daughter.
That's correct.
Well, when you made this statement, was it correct?
Yes, sir. Best of my...
Boom. I mean, that is a haymaker. That is a great point. That is a skillful, artful way to impeach somebody. And you got to get out the words that he said, because it may have been hearsay. But he got the words out that he heard the victim say to the defendant. And how he said it. And he yelled, and he was leaning over the seat. And again, it's confirming more of what the defense has been arguing throughout this case and not what the prosecution has been arguing. Those are important factors. And he asked if it was true. And he said, yes, it's true. Now they're going to quibble about whether you remember better then or you remember better now and what you actually believe happened. So we'll listen to that.
You would agree when you made this statement in 2014 that your recollection was much better on the date of this incident than it is in 2022 today.
Yes, sir.
Did you have a problem with saying that he was over the back of his seat? Is that a problem?
Is that, what do you mean in the statement that I had a problem?
Can I see your fancy chair? That's it.
So this is interesting, okay? So they're all laughing, and it's kind of a light moment in a serious trial. He said, "Can I see your fancy chair?" He said that to the prosecutor who did the direct examination and used that chair. So now he is taking that chair back up, and he's going to use it to prove his point and to disprove the prosecutor's point. He also is now going to make the prosecutor stand up, which is kind of a boss move in a trial. And again, these are older lawyers like my dad's generation, and they do some stuff that some younger lawyers can't get away with. Sometimes we can, depending on the case, but it's fair game to use that chair, so the prosecutor did. There's another chair that you can see at counsel table for the prosecution that he can sit in, so he's not forcing him to stand up, but he chooses to stand up, and it actually made for kind of a nice light moment where the prosecutor said, "I'm sitting in it," and he said, "Can I just use it?" And he says yes. So being cordial with the other side is also really important. They have respect for each other. They're working well together, and it's good for the jury to see that so they don't hate the defense lawyers in a case like this where they may hate the actions of the defendant. So I just thought that was an interesting moment as far as what happens in the courtroom when you have a good relationship with the other side and a working relationship with the other side and the judge. You can do things like this, and we do stuff like this all the time where we use each other's video, we use each other's easel and things like that throughout the trial. And what's great is when they write something and they create this demonstrative aid, and then you can use their demonstrative aid while you're cross-examining a witness or during closing arguments, which is what this lawyer is doing here, which is great. It's always a great move to do that. It's a skillful thing to do as a trial lawyer.
When you came, when the prosecutor was here, this is what you told the jury, that you called propped up. Is that what you call propped up?
Yes.
Or was he leaning, as your statement, leaning over the back of his seat?
He was not leaning over the back of the seat.
Not leaning, even though that's what you put in your statement.
Yes, sir. You're correct.
You must have been lying then when you made that
I
statement.
object to that characterization.
Approach.
A little gumption out of the prosecutor. "I object to that characterization." Now listen, you can't call witnesses liars. Usually that's frowned upon in a trial. But point is like you said this, and now you're saying it wasn't true. So is what you said in your prior statement not true? Sometimes you can ask it like that and not characterize him as a liar. The judge is going to sustain this objection. I'm going to skip through the sidebar, and then we'll continue on with the questioning.
So, was it propped up,
Yes, sir.
or was it leaning over the chair as you indicated on January the 13th?
He was propped up.
So he wasn't leaning over the, that was just something that you wrote that was incorrect on January the 13th of 2014.
Yes, sir. Yes, sir.
And you're a police officer, correct?
Yes, sir.
And by that time you were a police officer for how long?
15, 16 years.
And this is important now. He's building up his background. You're a police officer for 15, 16 years at the time. Now let's get into why that's important.
You must have been trained that when you're writing a statement, you've got that, write that statement precisely and accurately, correct?
Yes, sir.
Because in our system of justice, we can't afford to make mistakes, can we?
No, sir.
Using his own training as a police officer against him. Tons of times he's probably taken statements and explained this to people. Be precise, be accurate. But now this lawyer's saying, but you are now saying you weren't precise and accurate. Actually, you were. You were back then, and now that you've been coached by the prosecution, now you're saying propped up instead of leaning over. But before anybody coached you and you were explaining right after it happened, you said leaned over. I don't know about you guys. Let me know in the comments what you think is a more accurate statement. Right after something happens or 8 years later. And in the comments, you can put right after or 8 years later. As simple as that. And I think we're all going to agree that right after it happened is when your memory is most accurate. And I think this jury understands that by common sense. But you let me know, because you all are the potential jurors. You represent this jury potentially in the comments. So if you don't believe that, if you believe he's more accurate what he's testifying under oath in court today, that's fair. And that's what I want to know. I don't want to sway you, okay? Obviously, it feels like I just kind of did. But He's under oath, sworn police officer, swearing to tell the truth. Would you believe what he said on the stand, or would you believe what happened, what he made in a statement right after the shooting? It's important, so answer in the comments.
Especially police officers, correct?
Yes, sir.
The one thing is that you did not hear Mr. Reeves say a peep, correct?
That's correct.
In fact, you couldn't even see Mr. Reeves.
No, sir.
Is that correct?
That's correct.
Because it was dark, correct?
It was low lighting.
Here we go. We knew it was coming from the prosecutor's opening, and now he's going to argue with the defense. Don't argue with lawyers. Don't argue with defense lawyers. It doesn't ever turn out well, right? It's like, it was dark, low lighting. Low lighting? Like, what does that mean? What is low lighting? That's not something we use in everyday language, but he's going to say low lighting 100 times because it was probably what the prosecutor fed to him or what he heard some other witness say, and it just doesn't look good. So you can't do stuff like this. But let's watch it happen.
Is low lighting the equivalent of dark?
No, sir.
It's not.
No, sir.
Well, why couldn't you see Mr. Reeves if it was just low lighting? The prosecutor came over here and said, well, could you see this person? Could you see this person? But you couldn't see Mr. Reeves.
No, sir.
And you could only see a silhouette of Mr. Olson.
May I ask a question?
No, you can answer the question. You could only see.
Can I ask a question? No, but you can answer a question. It's great. And the judge is letting him go. Some judges will jump in there, but the judge is letting him go. And this lawyer's got control of the courtroom right now, and there's no better feeling than that. When you're just vibing and you're going and you feel like you've got control and you just keep rolling. Can I ask a question? No, but you can answer one. That's great to me. I mean, to me as a lawyer, I love seeing that. But you let me know. Maybe as potential jurors, he sounds like a jerk. Maybe he sounds too aggressive. Let me know. From my perspective, I'm loving it.
Okay.
You could only see
Yes, sir.
the silhouette
Yes, sir.
because it was dark.
That's correct. No, it was low lighting.
Oh, and then he gets him there. He gets him. Yes. Yeah. It's like when you're talking to your kids. It's like, what color's milk? White. What color are the clouds? White. What color is this? White. What color is this? White. And they say, what color is the sky? And they say white. You just get him to answer the next question. He's like, yes, yes, yes. And it's because it was dark, right? Yes. And then he stopped. He said, well, wait. It was low lighting. Again, that coached term to me. It's just, it's really fun to watch somebody hone in and do a good cross-examination. It's one of my favorite parts of trial.
When you heard Mr. Olson, you wanted to find out, quote, who was raising hell.
Yes.
Correct?
Yes, sir.
That's what was in your mind at that point in time.
Yes, sir.
You wanted to find out who was raising hell. Correct?
Yes, sir.
And the only one that you heard that was raising hell was that silhouette.
Yes, sir.
You don't know how long that silhouette, Mr. Olson, was raising hell, correct?
That's correct.
Because you were focused on the previews, correct?
Yes, sir.
Because your wife had to be the one to nudge you to say, hey, you need to pay some attention here.
That's so funny. It's like he wasn't even paying attention. He was watching the preview. His wife had to be like, hey.
Yes, sir.
You did not see the entire exchange that took place from Mr. Olson towards Mr. Reeves.
Not the entire, no, sir.
And you had no idea, therefore, if Mr. Olson had come over that chair on a previous few seconds, correct?
No, sir.
Because you were looking over there, correct?
Correct.
And so you don't know what was happening at that moment before you looked over there.
Correct.
What you do know is that Mr. Olson was raising hell and using the F word, correct?
Using or
Well,
used?
maybe I should say saying the F word. You want me to say it?
He said the F word.
Okay. And certainly that alarmed you because to hear that yelling with the F word in a theater is totally out of character, right?
Correct. Yes, sir.
You would never, in your entire life, expect someone to be getting up in the middle of a theater and using that word, yelling, right?
Yes, sir.
So again, that's great. Now that he's beat the witness up a little bit, the witness is more likely to agree with you as a lawyer. You get a couple shots, you impeach him, you let him know you're prepared. You've read all of his prior statements. You know what he's going to say. You know what everybody else says. He's more likely to agree with you because he could easily say, no, I don't think it's that weird to use the F word in the movie theater. He could say that, you know, whether it's true or not. I don't think anybody's like, you are obviously lying if you say that it's normal to use the F word in the theater. But because now this lawyer's on a roll and he's agreeing with what this lawyer's saying, he says, yes, this is out of character. I wouldn't expect to hear that. Yes, he's saying the F word, and the lawyer's trying not to say it again, right? But he's like, do you need me to say it? Because I will. Showing, I'm not scared. I'm here fighting for my client. And again, he's getting a lot of good points. He's saying that the silhouette was tall, leaning over the chair, raising hell, screaming the F word, which is all out of character in a movie theater. These are big points that he's getting on just another lay witness that was sitting in the movie theater and witnessed what happened.
And it alarmed you 7 to 9 seats away.
Yes, sir.
It alarmed you 7 to 9 seats away. So obviously, what do you think it did to somebody that's only 1 seat away? It alarmed you, it obviously alarmed them. And it wasn't even directed at you, it was directed at them.
You were doing your best to try to see what you could see, but all you could see was a silhouette and could not even see Mr. Reeves.
No, sir.
He starts to look at the...
But you know that that silhouette was facing in one direction and one direction when it was raising hell, right?
Yes, sir.
And it was facing at Curtis Reeves.
Yes, sir.
And it was in very close proximity.
Blows the whole entire row, entire seat. He admits, close proximity.
To Curtis Reeves.
Yes, sir.
And it was tall.
Yes, sir.
You certainly never saw Mr. Olson or this silhouette with a phone in his hand, did you?
Excuse me? I'm sorry.
You never saw this silhouette with a phone in his hand, right?
No, sir.
All you're seeing is a silhouette, right? No
No,
phone.
sir.
But you say that, I guess you called it a flick of popcorn.
Yes.
Now, tell me, if you were only able to see a silhouette, how could you see someone flicking?
It was just an arm, a hand, and then it was a flick.
So, meaning an arm and a hand towards Mr. Reeves.
It was just out over where the silhouette was standing in a flick.
So that hand went from the silhouette out towards Mr. Reeves,
Correct.
correct?
Yes, sir.
Okay. In very close proximity.
Yes, sir.
And it was then almost instantaneously. You heard the shot.
Yes, sir.
In fact, you wouldn't be surprised if it's less than a full second.
Within a couple seconds. Yes, sir.
Well, you didn't, you're
No, I didn't.
guesstimating, right? And my question is, you wouldn't be surprised if it was less than a second.
No, sir.
You didn't see the gun because it was dark.
Correct.
Because it was dark. Correct. Got him to say it there with no argument.
And so this is a good one. You couldn't see Mr. Olson. Couldn't see the gun.
No, sir.
But you saw popcorn?
I see. Yes, sir.
How could you see popcorn if you can't see anything than a silhouette of Mr. Olson, and you can't see a gun, and you can't see Mr. Reeves? How are you able to see a popcorn?
He's looking over to the prosecutor.
No, we're talking about the incident. On the date of the incident, was Mrs. Olson seated to the right of Mr. Olson? A firearm exposed to the general public, correct?
Correct.
Because they're going to think that you're a threat, right?
Yes, sir.
You've been trained on that in your own law enforcement career, right?
Yes, sir.
So you didn't... Tough one, no?
No, it's not tough. It's just, that's what it was.
That's what it was. Now, you gave us a statement on direct examination where you indicated that the shot took place and Mr. Olson fell to the ground?
No, sir.
He didn't fall to the ground.
No, sir.
Okay. So shot took place. What did Mr. Olson do?
He held his hands over his chest
Okay.
and said, "I can't believe he shot me."
Okay.
And-
That quickly. Shot. I can't believe he shot me. And then what happens?
He kind of went towards the north side or away from me of the building, down that same road he was on.
Okay. And
Eventually, I guess he fell.
you didn't see him fall.
No.
Okay. And so you saw all that from your vantage point of where you were,
Yes.
meaning 7 to 8, 9 seats from the incident, because it's shot, Mr. Olson, statement, right? So
Yes.
you're still at your seat,
Yes.
right?
Yes, sir.
And so can you tell me how long it took you to get from your position at your seat to Mr. Reeves after that took place?
$30 seconds.
Okay.
I wasn't timing it up.
You never saw Mrs. Olson
No, sir.
at all.
I seen her at the very end,
Well, at the very end of what? After the shot?
after they turned the lights up and people were,
But before they turned the lights on, you didn't even see Mrs. Olson
no, sir.
because it was dark.
Yes, sir. No, it was low lighting.
But somehow you said on direct examination that she was seated to the right of Mr. Olson? Mrs. Olson? Did you
She
say
was
that
to
on direct? Remember, in direct? And they're asking you where Mrs. Olson was? You said, well, she was seated to the right of Mr. Olson.
I don't remember that. You talking about today?
What's that?
You talking about today?
No, we're talking about the incident. On the date of the incident, was Mrs. Olson seated to the right of Mr. Olson?
I don't know.
Because you didn't see her.
No, sir, I didn't see her.
Now, you get to Mr. Reeves. You're a trained law enforcement officer, right?
Yes, sir.
In a situation where you've just had a shooting, certainly you don't want to have a firearm exposed to the general public, correct?
Correct.
Because they're going to think that you're a threat, right?
Yes, sir.
You've been trained on that in your own law enforcement career, right?
Yes, sir.
So what's important about this now is they're trying to justify the actions after the shooting of the defendant. He wasn't trying to hide or act like he didn't do it or act like somebody else fired the shot. He was, again, doing exactly what this witness says he was doing and would do if he had a firearm in this situation and when he grabbed the firearm in this situation. So they're trying to justify the actions of the defendant. That's the point of this line of questioning.
So you didn't find it odd whatsoever that Mr. Reeves, immediately after the shot, put the gun on his lap? You weren't surprised by that.
Yes, sir, I was.
Why would you be surprised by him putting it on his neck, on his lap, when he didn't want to expose everybody to think that he was someone that was dangerous. You certainly didn't want him to have a gun in his hand after the shot,
Yeah,
right?
I'm going to object to counsel testifying.
It is cross.
It's not proper cross.
I'll overrule.
Right?
I'm going to object to counsel testifying. He says, it is cross. And then he said, it's not proper cross. The judge overruled it. It's like, stop. Just let the lawyer ask the questions.
Right? You do not want, you've been trained in law enforcement. Hey, listen, if there's a situation with a big crowd, especially if you're not in a police uniform, you don't want to have a gun in your hand everybody thinking that you're a threat, right?
That's correct.
And so when you went over to Mr. Reeves, I'm sure you thought to yourself, oh, highly trained individual, he puts the gun
Your
right
Honor,
on
I'm
his
going to
knee.
object to that. It's totally speculation. Facts not in evidence.
It's cross, Your Honor. I can ask him that question.
I understand it's cross, but it's improper cross.
No.
Overruled. Do you hear how defense attorneys like this who say things like, it's proper cross? No, I can ask him that, Your Honor. Just saying this while the prosecutor's arguing his objection, it's very authoritative. And I'll tell you from experiencing it, seeing it, watching it, doing it, it has an effect on judges. Where if you're confident enough, they are more likely to overrule an objection like that, especially on cross and closing arguments where you've got a lot of leeway as a criminal defense lawyer. And that's exactly what she did here, overruled. He said, no, that I can absolutely ask that judge. It was right here. That's proper cross. And as the prosecutor is trying to spit out an objection.
Right? You went over there and said, ah, yeah, put that gun right there. In fact, is that correct? Highly trained individual, put it there. Nobody sees him with a gun in his hand.
I didn't know that he was highly trained.
No, at that point he didn't, but you must have thought that. Why would you put it on his knee?
No, sir, I didn't think that at all.
You didn't think that. But I can tell you that when you picked up that gun from his knee, you quickly hid it, right?
That's correct.
Because you didn't want everybody in that particular theater to think that you were a threat.
That's correct.
Because you were not in a police uniform.
That's correct.
And what happens is, if they think you're a threat and somebody's got a gun, now he starts shooting at you, and these poor individuals in the theater may get shot.
That's correct.
You wanted that gun out of sight for the right reasons, right?
Yes, sir.
You didn't want anybody misconstruing you to be an aggressor.
That's correct.
Now, when you went over to Mr. Reeves, pretty close after the shot, and you looked down, can I borrow your chair? Sorry.
Can I borrow your chair again? I'm sorry. Oh, the prosecutor's like, I should have brought my own chair. It's
Mr.
so funny when
Reeves,
stuff like
Mr.
this
Reeves.
happens. This is fun.
Is still seated,
Yes, sir.
right?
Yes, sir.
And right between his legs, you're here, right? Standing up.
Yes, sir.
And you look down, and right between his legs, you see a phone.
Yes, sir.
You being a law enforcement officer, knowing that that could be a piece of evidence, right?
Yes, sir.
You make sure that when Mr. Reeves is finally cuffed, that you tell the officers, hey, by the way, there's a phone here that you need to pay attention to. Correct?
Yeah. Yes, sir.
You told Mr. Reeves that you were a law enforcement officer when you approached him.
Yes, sir.
He told you, likewise, that he was a retired law enforcement officer.
Yes, sir.
You didn't have to wrestle Mr. Reeves.
No, sir.
He was very cooperative,
Yes, sir.
correct?
Yes, sir.
And he told you that there was something, someone had hit him, right?
Yes, sir.
Objection, hearsay, Your Honor.
Interesting. Usually only one lawyer is supposed to object, and it's the lawyer that does the direct, which is not Scott, but the other prosecutor in this case. And now Scott heard something and he objects to hearsay. So it's just interesting when it jumps in. Certain judges are sticklers for that, where only the lawyer who does the direct and who does the cross, so only one lawyer per witness each for each side, can object, can make the arguments for objections, can question the witnesses. Usually it's limited to just one lawyer per side, but most of the time the state gets away with whatever they want.
Roach?
They were talking about something that Mr. Reeves said about something about his eye, but he also told you before he did that he was hit.
He said something was in his eye.
Did he say that he was hit?
He was hit with something.
Okay. That he was hit with
Again, he's
something.
quibbling over these words, and then he ends up caving and
The
agreeing
time
with the
that he
lawyer.
told you that was right when you approached him.
Yes, sir.
And the lighting was still at that point that it was dark,
It was low lighting. It wasn't dark.
low lighting. And you didn't have a flashlight with you,
No, sir.
and you weren't going to be looking for any redness on his face. You were looking for, oh, is he bleeding? Does he have a gash, right?
Yes, sir.
You weren't looking for anything that had any other indicia of injury.
That's correct. Yes, sir.
In fact, you didn't even get real close to him, did you?
No, sir.
In fact, you remember Mr. Reeves' son, Matthew Reeves,
Yes, sir.
coming up,
Yes, sir.
and him identifying himself also as a police officer,
That's correct.
correct?
Yes, sir.
And you remember him having blood all over his hands because he was the one that was attending to Mr. Olson, correct?
That's correct.
And you didn't want to talk to him either.
No, sir.
Now, we had some testimony concerning interviews, right?
Yes, sir.
And you've been trained, obviously, in your career, that when they give you a voluntary statement form, you're not telling this jury that some police officer had to come over and tell you how to fill it out.
No, sir.
So again, this is twofold argument here. You know how to fill out the statement, so what you wrote down is true. Nobody had explained to you, a police officer who has explained this to other people. So correct. So now we're building that that's true. But also, what they did in this investigation was wrong. And now he's getting into his training. And if you listen to the defense's opening, they talked a lot about how they did not do this properly. They did not question witnesses properly. They didn't separate them properly. They didn't create the scene like they were supposed to properly. And now we're going to get into a little bit of that about how these statements could have been contaminated one way or the other. Not just his, but other people's.
You know how to fill it out, right?
Yes, sir.
You're going to put in as much detail as you possibly can.
Preliminary. Yes, sir.
And the information that you're going to put in this document, you're going to make sure that it is true,
Yes, sir.
right? Because
Yes,
you're going to be placed under oath at some point in time, right?
Yes, sir.
So it's not a document to fool around with.
No, sir.
And so, early in your career, very early in your career, probably your academy, you were taught about something called contamination, right?
Yes, sir.
Witness contamination.
Yes, sir.
And that is a very basic investigative tool, right?
Yes, sir.
That you're not supposed to allow witnesses to come into contact with each other. Correct?
That's correct.
That's very dangerous, you would agree.
Yes, sir.
So they're going to have their own expert testify to this stuff, but it's even better when you can use a prosecution witness to give you the details you need that this investigation wasn't done well. You may not even need an expert because an expert you paid as the defendant is not as convincing as someone who is an unbiased witness that's called by the prosecutor. And even he is going to give them all this stuff showing that this investigation was not done properly and these witness statements were not gathered properly according to police procedure.
It's very dangerous in our system of criminal justice, right?
Yes, sir.
Because people hear things, and whether it's right or wrong, they start adopting it for themselves, right?
Yes, sir.
And then you don't really get to know whether the witness's testimony is their own or 15 other people that they heard that statement from.
That's correct.
And so you've been trained as early as the academy, separate these witnesses.
Yes, sir.
And you were there in that theater and just the opposite happened, correct? You were a congregating group right in that theater, correct?
I can't speak for everybody else, but I was with my wife. Yes, sir.
Well, you were with your wife and there was a group of people around you.
Yes, sir.
And not a single police officer came up to you and said, Mr. Hamilton, let's make sure we got to separate you all. Please don't talk to anybody about your testimony, right?
That's correct.
And you didn't hear that police officer tell anybody in that group, 30, 40, 50 people, whatever they were. You didn't see any police officer come up and say, hey, group, separate, do not talk about your testimony with anybody else.
No, sir.
And you certainly know that there was a battalion of Pasco County Sheriff's officers all over the Grove Theater.
I don't know about a battalion, but there were several in there. Yes, sir.
I don't know why quibble about these words is just doesn't look good as a witness. It makes you look like you're biased to the prosecution when you argue about the word battalion.
Many, right?
Many. Yes, sir.
And knowing that, you as a police officer, you get interviewed by Detective Proctor, the lead detective in this case, right?
Yes, sir.
And he interviews you with your wife there, and he interviews your wife with you there, right?
Yes, sir.
And let's take it one step further. Before he even turns on the tape, you all have a little discussion, right? Off tape.
I don't recall a discussion off tape.
Well, you certainly don't think that would be appropriate, right?
To have a discussion with both of us there?
Off tape.
According to what we're discussing,
Well, the case.
I don't recall that discussion.
If it happened, that would be improper.
Yes, sir.
So this is a great move by a criminal defense lawyer, right? You've got to be able to adapt. You've got to be able to know when someone's giving you something that you can use later. So he was first going to talk about the fact that they had a discussion off tape and about how that's improper. But this guy says, I don't remember an off tape discussion. And he says, that's fine. You don't remember it. But let's say it happened. That would be improper, right? As a police officer. You don't have a discussion, then start the recording as a witness in a case. That would be improper, right? That would be horrible. You would never do that if you were the investigating officer, right? And he's going to say yes to all of those questions because later the defense attorney is going to get, I would guess, this investigating officer to admit that they had a discussion off tape and to show once again that this police procedure was improper and these statements were contaminated. So it's really great. You wanted him to say yes and admit the off-tape conversation, but if you don't get that sometimes as a lawyer, you move to the next best thing and still get him to comment on it if it would have happened. Now, it could be speculation, but he is a police officer and he can say whether or not an off-tape discussion is improper. So he's able to get through kind of that speculation, even though the prosecutor did not object here. So let's continue and see how he uses an answer maybe that he wasn't expecting or not the best answer he could have gotten. He still turns it into useful testimony.
Highly improper, right?
Improper.
You would have never done it in your career as a law enforcement officer.
No, sir.
There is no reason whatsoever to have a conversation about the case when you have a tape recorder present without turning that tape recorder on.
That's correct.
Wow. See, he's just agreeing with him at this point because now nothing the investigating officer says is going to be a good reason because he already admitted there's no good reason to have an off-tape discussion. Really good job.
When you went into that interview room, you wanted to tell Detective Proctor what you knew.
Yes,
Right?
sir. Yes, sir.
That was your purpose.
Yes, sir.
Homicide case, right?
Yes, sir.
You expect thorough interviews in a homicide case, right?
Yes, sir.
How long have you been on the stand, you think? You came in at 1 o'clock?
A little after, yes, sir.
It's 2:27, right?
Yes, sir.
I've been up here asking you a lot of questions, haven't I?
Yes, sir.
Your interview with Detective Proctor was 5 minutes.
Okay.
You think that's a thorough interview in a homicide investigation?
Boom, right there. He's saying that the investigator didn't do a thorough job. We've been talking to this guy for 2 hours here at trial, and when they were actually investigating the homicide, 5-minute conversation. We do this all the time in our cases where if there's a surgery and we have our surgeon that's spent months with the client, they did the surgery on the client, they know the client, they've been treating them for a year, and then they have a compulsory medical exam doctor come and spend 11 minutes with the client, and now the compulsory medical exam doctor knows everything about the client, but we compare the time spent. Similar in criminal cases. If somebody spent 5 minutes, I don't care who you are, if you're on a jury, that is not a thorough investigation.
No, sir.
You certainly wouldn't have done that, right? And you were never a homicide investigator. You would have never done that in a homicide case, would you?
No, sir.
I would object to the speculation there because he just
Because our
admitted
system of
he
justice
doesn't have that kind of
requires
experience.
thoroughness, correct?
Yes, sir.
And again, all of this is creating reasonable doubt. Our system of justice requires this stuff. They're not proving something, they're adding some reasonable doubt in there, okay? Which only goes so far in a self-defense case, but it's interesting because they're just trying to put little doubts, plant seeds of doubt in the jurors' minds.
The one thing that you know is that when you went up to Mr. Reeves, took the gun from him, he was concerned for Mr. Olson.
Yes, sir.
I have no further questions.
All right, and that's where the cross ends, and he ends it with a little bit. He talked a little about how Mr. Reeves wasn't combative, he didn't try to lie, didn't try to hide it, and he did care for Mr. Olson. He didn't want something bad to happen to Mr. Olson. It wasn't a depraved heart, evil killing. It was a response in self-defense. That's what they're trying to build up to. So, while I still think the prosecution's ahead in this case, I think that was a great cross. Let me know, give me a letter grade for this cross-examination, in your opinion, A through F. I can't wait to see the comments. In the comment, drop your letter grade, A, B, C, D, or F, and we will discuss it more on our live tonight at 8:30 p.m. Eastern Standard Time. But for now, that's all we've got, and we will continue to follow the cases you guys are most interested in.
Thanks for watching this episode of The Lawyer You Know. If you like this content, please share it with your friends. Make sure you subscribe to our page and like our videos. If you want some interaction, get in the comments and we'll be sure to get back to you. If you want to know any more information about our firm or this page, you can find out in the description or visit tragoslaw.com.